Welcome to EU Privacy for All, Session 41 on GDPR, Territorial Scope, Article 3. European Parliament suggested several modifications in Article 3, such as the fact that the application of the regulation would not depend on the fact that the processing would take place in the Union or not. The controller would be targeted, but also the processor. And when the offering of goods or services would be the basis for application of the regulation, it would be irrespective of whether a payment of the data subject would be required. On its side, EU Council retained the proposal that the offering of goods or services would be irrespective of whether a payment by a data subject would be required to condition the application of GDPR, and also added that the monitoring of data subjects' behavior, as far as their behavior takes place within the European Union, would be targeted. The basic rule laid down by Article 3 is that the regulation applies in the context of the activities of an establishment, of a controller or a processor, regardless of whether the processing would take place in the Union or not. That is to say that for a controller or a processor not established in the Union, the regulation would apply whenever the offering of goods or services targets EU citizens, irrespective of whether a payment of the data subject is required. Second option would be the monitoring of their behavior as far as it takes place within the European Union. The regulation will also apply to a controller not established in the Union, but in a place where the national law of a member state would apply by virtue of a public international law. Let's focus on some key provisions and inputs in the recitals of GDPR. Recital 19 makes really clear that the establishment, which is a core notion in Article 3, implies the effective and real exercise of activity through stable arrangements. The legal form of such arrangements is not a determining factor. Recital 20 also makes clear that it should be determined whether a controller or processor is envisaging to offer goods and services to data subjects in the Union. To do so, some factors should be taken into consideration, such as mere accessibility, email address, other contact details, use of a language. As such, those parameters are insufficient to ascertain such intention. However, a body of evidence could be assessed, and the use of language or a currency generally used in one or more member states might make it apparent. Recital 21, focusing on the monitoring of the behavior, also makes clear that determining whether a processing activity can be considered to monitor the behavior of data subject could be based on whether individuals are tracked on the Internet, including potential subsequent use of data processing techniques, which consist of profiling an individual. Recital 22 also outlines that, whereas national law of a member state applies by virtue of public international law, the regulation would apply, for instance, in a member state's diplomatic mission or a consular post. Each supervisory authority should cover the processing in the context of the activities of an establishment of the controller or processor on the territory of its own member state. Whenever a controller or processor is targeting the offering of goods or services on EU market or monitoring the behavior of EU citizens, it should designate a representative, unless the processing would not be likely to result in a risk for the rights and freedoms of individuals. The main establishment defined in Article 4.13 for the controller and the processor also makes clear that the central administration should be a core criterion to be used in order to define main establishment location, but some exemptions are provided and they will be defined in a different session. Currently, the directive lays down in Article 4 on national applicable law several key principles that are still laid down in GDPR, such as the fact that the context of the activities of an establishment is a core notion, the fact that being not established in a member state territory does not entail that the directive would not apply, and the fact that the controller, not being established once again in the community territory, but making use of equipment situated on the territory of a member state, shall be a reason to apply the directive. There is also the obligation to designate a representative for the data controller. What should accountable data controllers and processors get prepared for? First, knowing when the GDPR would apply. First case is in the frame of the context of the activities of one of their establishments in the Union, regardless of whether the processing takes place in EU or not. If the controller or processor is not established in EU, GDPR will apply whenever there is an offering of goods or services irrespective of a payment, or when there is monitoring of EU citizens' behavior. The last case targets the controller only, not being established in the Union, but in a place where the national law of a member state applies by virtue of public international law. The notion of establishment implies the effective and real exercise of activities through stable arrangements, and the legal form of such arrangements is not determining. Knowing whether it is apparent that the offer of goods and services or the monitoring of EU citizens targets one member state depend on factors such as the use of language or currency or the existence of profiling. Finally, whenever falling into the scope of GDPR, controllers and processors should designate a representative in EU, unless the processing is unlikely to result in a risk for the rights and freedoms of EU citizens. The question we can have now is knowing more about this notion of context of the activities of one or their establishment that is used in GDPR and commented broadly by ECG lately.